Good morning, everyone, and thank you for all coming out to this important announcement. I'm pleased to have Asher Honickman join me for today's press conference. I've retained Mr. Honickman as my counsel to bring forward a constitutional challenge to Ontario's election financing laws. I also want to thank my many supporters who have financially supported this constitutional challenge. Specifically, my application to the courts is that the current laws violate Section 3 of Canada's Charter of Rights and Freedoms. My application, should it be successful, would finally overturn a long-standing injustice for independent candidates and diminish the stranglehold that political parties have over our democracy by returning a level playing field for all those who seek public office. My application would permit independent candidates to accept donations at any time for their re-election, which at present is unlawful and a privilege only enjoyed by candidates of recognized political parties. It would also end the unfair and unjustifiable advantage that political parties have created for themselves and diminish the abilities for parties to hold hostage or coerce discipline from members who place their constituents above party allegiance. Our current election financing laws have served to obstruct the introduction of new people with new ideas to elected office and frustrates representation of constituents by unduly limiting any challenges to the status quo. I believe these laws are both a distortion and a corruption of our democracy. While political parties have an important and even an integral role in our legislature and parliaments, so do others who are independent of partisan influence. This application does not seek to undo the party system, but to broaden out forms of representation. The public has been sending a message that they are not satisfied with our current party system. The growing apathy for all things political among the public is a direct result of a system that puts party interests above the public's interest. The cult of leadership that party politics has become and the tedious representation it creates are an embarrassment to the spirit and tradition of representative government, and often works outside of the public interest. That's why I have served an application with the court. I am challenging the constitutional validity of the laws that make it almost impossible for most people to participate in our democracy the way the Canadian Charter of Rights and Freedoms envisions. Many of you have covered my career since I was first elected in 2007, and you will remember that I was elected on a platform and commitment to the people I was running to represent, to be their voice at Queen's Park. They have given me their confidence in 3 subsequent elections since first electing me with a plurality of their votes. I know many people in all 4 elections voted for me not because I represented a party, but because of my commitment to always put their interests ahead of those of any political party, and I plan to continue to do so. My charter challenge is to ensure that people can have the representation they want, whether that candidate is a member of any party or not. And with that, I'd like to thank you, and both Mr. Honickman and myself are available to answer any questions on this charter application.
Randy, we know you're popular in your riding, but that it also can be quite difficult for independents to get elected. Do you think that these provisions that prevent you from fundraising outside a campaign how much of an impact will that have on your ability to get reelected?
Well, that is really the essence of why we have seen such a stranglehold of party candidates elected. The current laws have frustrates and makes it unlawful for me now to receive donations or solicit funds for my reelection. Up until March 15th, I could accept funds every year through my riding association. I could end transfers and additional funds because I was affiliated with a party. Now that I'm not affiliated with a party, those have evaporated and are unlawful. And to such a degree that, I must wait until the election writ is dropped before I can even request from the Chief Electoral Officer the permission to solicit funds or receive funds. So, you go to less than a 30-day period where you're allowed to raise funds for your reelection.
Randy, back in March, you made some pretty explosive allegations about potential unregistered illegal lobbying to do with the Premier's close advisors. You haven't really followed up on that since. So what is happening with that, and what is the public to think about these allegations that you've made?
But this is a press conference on a constitutional challenge that has been filed and served on the Ontario Attorney General. So we're going to keep our comments to the subject at hand.
Well, Randy, I mean, you of all people would know that we can ask about any topic that
Well,
we
sure.
want, and you did speak about this publicly. You gave a press conference about it, so
Yeah.
I'm just following up on what has happened with that.
I gave those comments back in March, and we know that the NDP have requested the OPP to investigate, and I understand that the OPP do not comment on ongoing investigations. So I don't have any further knowledge about where that investigation may or may not be at the current time.
Has there ever been a charter challenge anywhere else in Canada with respect to independent candidates' ability to fundraise?
Well, not with respect to that issue specifically, but the courts have afforded a very broad interpretation to Section 3 of the Charter in other contexts. So, for example, in the context of smaller parties taking on larger parties and advantages that larger parties enjoy. And what the courts in Canada, including the Supreme Court, have repeatedly said is that Section 3, which on its face guarantees just the right to vote, is actually much broader than that and guarantees a right to vote in a fair election in which all the candidates are effectively treated as equals, where no candidate is given any sort of institutional, systematic advantage over another one. And it's those advantages that we're challenging in this application.
Can you explain to us in a little more detail what the Election Finances Act actually says? I assume there isn't a section that explicitly says independent candidates can't raise money.
No, not exactly. So there's essentially four bases why we're challenging the Election Finances Act. So first of all, as Mr. Hillier was saying, party-endorsed candidates can raise money outside the election period through their constituency association, because constituency associations can raise money all year round. And there's a provision of the Election Finances Act which allows constituency associations to transfer funds that they've raised to the candidate once the writ has been issued. So that constituency association can use the money to promote the candidate, but can also eventually transfer money to the candidate. And because the constituency association can raise money, the candidate can also raise money effectively in much higher quantities, because the constituency association, the riding association, has an entirely separate limit of maximum contributions from each contributor. So the constituency association can raise $1,600 per contributor per year, every year. Mr. Hillier could then only raise $1,600 per contributor after the election writ has been issued. Thirdly, there are allowances that are provided both to parties and to constituency associations. Now, this provision is interesting because the Ontario government has said they're going to repeal it. in, I think it's 2022. So they're potentially acknowledging a constitutional problem with this provision already. So that provision's being repealed, so they say, but it's on the books right now. And of course, Mr. Hillier's not entitled to any allowance. And then the fourth distinction is actually very explicit in the legislation. It says that after the election is over, a party-endorsed candidate gives any surplus they have back to their constituency association, which essentially holds it as a bank, can continue to promote them, etc., while they're in the legislature, and then can transfer it back to them when they become a candidate again. Mr. Hillier, if he's able to successfully run as an independent and is able to retain a surplus, he has to give that entire surplus back to the chief electoral officer. He's not allowed to see that money ever again. So that's actually a very explicit distinction between independent and party-endorsed candidates. So those are the main elements of the act that we're challenging.
Randy,
Is there
on the
anything
per
that-
vote subsidy, you as an independent, and you and Jim Wilson and Amanda Simard as independents, you don't get any of the per vote subsidies that the parties go. Are the Tories still getting the per vote subsidy for the votes that you got and the vote that Amanda got and Jim got?
That's correct.
So it just goes into a pool, even though some of its
It
votes go to.
it gets funneled back to the riding association, and the riding association is allowed to expend and disperse or transfer those funds in any fashion.
So in effect, with an independent like yourself or like Jim Wilson or like Amanda Simard, their vote subsidy is going to be used against them in the next election because the party can run candidates against them
That's
as
correct.
independents.
Exactly.
Is there anything stopping an independent candidate from having a constituency association?
That is really the crux of it. Right now, constituency associations can only be recognized through a recognized party.
Yeah, only a registered,
A registered.
party can form a constituency association. And that is the crux of what we're challenging. So the application really seeks two things. In the first instance, we're seeking to broaden the definition of constituency association and registered constituency association. And because this under-inclusive concept of constituency associations permeates the entire act, because we see it mentioned, something like 270 times in the act, we're taking the position the entire act has to be declared unconstitutional so that the legislature can go back and rewrite a more inclusive definition. Alternatively, we're targeting some of these specific provisions that I was discussing earlier, but really the entire act in itself, in its totality, burdens independent candidates with these various disadvantages that we've been talking about by preventing them from forming their own constituency associations. And were they in a position to form their own constituency associations, and were they in a position to transfer money from their constituency associations, we would see a more even playing field that is in accordance with Section 3 of the Charter.
Randy, have you met with the integrity commissioner
No.
regarding,
No.
not at all, regarding your other
Not
matter?
recently.
How many times have you met with them?
I don't have an exact count, but I've met with them a number of times over the years, but not
Okay.
recently.
Okay, I'm talking about the matter that you brought forward in March. So
Not recently, no.
Okay.
No.
Has there been any outreach from the Tories to you about coming back into the fold, or no?
No.
No.
No, I was quite explicit.
Yeah.
That I have no desire or interest or would, under the current management structure and leadership of the party.
So, yeah, I know you said, OPP is dealing with this matter, but in terms of following up on the March matter, I mean, what do you expect to ever close the loophole that you left hanging out there, or what's the public to
Well,
think
that's,
about some of
the
these?
OPP will have to be the ones who provide information on that. I'm not in any position to be able to provide information about what the OPP may or may not be doing.
And the integrity commissioner is still okay?
I've not filed anything with the integrity commissioner.
Thank you.
Thanks. Can I get a spelling of your name?
Sure. First name is Asher.
A-S-H-E-R, yeah.
Last name is Honickman.
And you're a constitutional lawyer, or what kind of lawyer?
I do all kinds of civil and constitutional litigation. I'm a partner at a firm called Matthews Abogado.
And so this application is with which court? It's with
In the Superior Court
Ontario
of
Superior
Justice.
Court? Yeah.
It's been filed.
It's been filed and it's been issued and it has been served upon the Minister of the Attorney General. And we've not, as of yet, received any official response.
Yeah, I might add, Ontario is not the only legislature that has this framework in election financing laws. This will have, should it be successful, will have serious, it'll have ramifications on the federal election financing laws and the independent members seeking office there, as well as other provincial legislatures, which all have varying degrees and differences between their election financing laws.
So it could have an impact on Jane Philpott and Jody Wilson.
Yeah,
Absolutely.
we've had some discussions. And, it is unlikely that there would be any resolution to this notice before the October federal election. But should they be re-elected as independents, it will have could have a profound impact on what they do afterwards.
You started to say we had some discussions with them.
Yeah, different various friends of friends we've been chatting amongst independent members.
Are they supportive of your challenge?
They haven't come out and said anything yet. I think they want to focus on the October general election because, like I said, this is not going to be argued in the Superior Court before the general election. Unlikely, anyway.
Unfortunately, our legal system, as great as it is a lot different from U.S. TV shows where someone gets arrested and they have the trial that afternoon, or someone brings a lawsuit and it's heard the next day. For various reasons, we don't anticipate a hearing before October, and likely not before the end of the year. But we'll see how things go.
And maybe just for clarification, there is an obligation for a response to the application, and I'm
Yes.
not sure what that time frame is.
Right. So the ministry was only just served, so we're still in early days, and I anticipate I'll be in touch with someone from their office. This is very standard for them to receive constitutional challenges, so we do anticipate to get the ball rolling on this fairly soon with delivering of affidavit material and then eventually proceeding to a hearing.
Thank you.
Thank you very much.